Ladies and gentlemen, welcome to the webinar. Today's seminar topic is from our first 30 minutes series. Today's topic is 5 key considerations when buying or selling a healthcare practice. Our presenter today is attorney Eric Boughman. If you'd like a copy of the presentation, you can find that in the handout section of the webinar interface. Without further ado, let me turn it over to you, Eric. Go ahead.
All right, thank you everybody. Good afternoon. Thanks for joining us today. Hope everybody's doing all right while they're on lockdown, quarantine, or whatever situation you have going on. For our office, we are operating this week and will be for the foreseeable future, but we're mostly working remotely. I happen to be in the office today, and so we're broadcasting live from our main office here in beautiful Maitland. I want to say thank you to Advent Health. They had agreed to host us, and we were going to do the seminar from there, but obviously with what's transpired over the last few weeks, we've decided to do this just by webinar, do it remotely from here in our office. Maybe we'll resume with Advent next month on the next webinar, seminar, or sometime thereafter in the future. With that being said, I'm happy to bring you today another series in our what we're doing every month here, which is the first 30 minutes. This is essentially a 30-minute conversation about things that we talk about with clients or with other professionals in the beginning of a potential engagement. And we'll be talking about various topics, mostly from a high-level overview. We're going to cover some main big bullet points today, and we'll get into a couple details, maybe try to hopefully teach you something that you didn't think about before or present it from a new perspective. And this is 5 considerations when buying or selling a healthcare practice. I will say that many of these considerations overlap into other businesses as well. So you may have another business that you're looking at being involved in a purchase or sale. So some of the concepts are the same, but there's a few concepts that are unique to healthcare, particularly because it's such a regulated industry, that we want to point those out as we go along. If you have questions along the way, Tony will keep an eye out for those. And I'll try to do so as well. If we don't get to your question in the next 30 minutes, please feel free to reach out by phone or email, give me a call, or set up a time that we can talk, and I'm happy to address those issues in more detail. So with that said, simple outline. I'm working off of my laptop today, so I'm just keeping track of the time. I want to be respectful of the time of everybody in our audience. There's some materials that have been dropped into the GoToWebinar presentation panel, and you can pull those materials down. And again, if you have questions about any of this stuff as we go along or afterwards, please let me know. So I'm going to take a little bit different approach. In a half hour, we're not going to cover all of the nuances of a purchase and sale transaction. We have a corporate department here at Forster Boughman that handles transactions from multi-million-dollar deals to much smaller deals in the healthcare industry and across various other industries and business. We just recently helped somebody sell a business in the, it was in the above $10 million, not a huge transaction, but pretty big. And there's a lot of pieces to that. There's a few people that are involved. There's tax considerations, there's technology issues, there's regulatory issues, corporate issues. And what I'm going to do is I'm going to take some of the points that I see that come up when something goes bad. In a litigation type matter, when somebody comes in, when we get a client who comes in and says, all right, I was involved in this transaction, usually it's the buyer side, but if somebody comes in and says, okay, I was involved in a transaction, it went bad, here's what happened, what are some of the common mistakes that we see or common issues that come up? As many of you may know, I spent about the first 10 to 12 years of my practice engaged primarily in litigation, business litigation, representing a lot of different healthcare groups and partners in those practices, as well as technology and other business, real estate. That was a hot area in Central Florida and has been for years. And as I was working with these folks, I expanded my practice to encompass more of the transactional issues and try to help people avoid the most common pitfalls as they go forward. So we're going to take some lessons that we pick up from what happens after a transaction in a lawsuit. And what we realize is that if you spend the time and you spend the resources on the front side, you can oftentimes, that serves as great insurance on the back side to make sure that you don't have a bad situation. I should also mention, by the way, that I think everybody can see me, but I can't see you because of the computer that I'm working off of. So hopefully we're somewhat making eye contact. All right, and with that, and my slides are not advancing. Tony, if you're controlling the slide, can you give me the next one? Okay. A little bit of technical difficulty here. Pardon me. There we go. All right. All right, so we're going to talk about, again, 5 considerations today. I've also got some bonus topics for you that we'll hit, time permitting. First thing I want to talk about is the letter of intent. Before you even start negotiations, and sometimes before you even make people aware of your interest in a transaction, you want to consider whether you want to keep that information confidential and have a confidentiality agreement or a non-disclosure agreement. People refer to them as NDAs, the main acronym. You usually want to have something in place that protects you in case the deal doesn't go forward. If you're contemplating a transaction and don't finish it, you don't want one of your competitors or sometimes your vendors, your employees, customers, patients, other folks to know that you're potentially contemplating a transaction. So you'll oftentimes start with your confidentiality provisions in your, even as a preliminary to your letter of intent. The letter of intent is essentially the major business terms of the deal. So parties get together, and this could be, it doesn't have to take on any formal format or shape or form. It can be simply a list of bullet points or deal points that the parties contemplate. Usually you're talking about things like price, what type of financing, if there'll be any seller financing, if this will be a cash transaction, and then whether or not it's going to be an asset sale or a stock sale. Stock refers to any type of equity, really. It can be stock or shares in a corporation, membership interest or units in an LLC, or partnership interests in some type of partnership, whether it be a general partnership or a limited liability partnership. Once you outline the basic business points, you get the parties on the same page. What's the price? What are the terms? What's the transaction going to look like? From a high level perspective, what assets is it going to be? All the assets or just some of them? And how are they going to be sold? Sometimes you'll cover such things as post-sale employment, whether or not employees or owners of the selling business are going to continue with the buying business. These are the deal points that the lawyers use to frame out the deal. And so once the LOI is done, you then get the lawyers involved to talk about your legal points. And there will be some legal issues in the LOI as well, but most of that will come with the lawyer's involvement, typically, unless you're trying to go it alone as a buyer or seller. And so one of the interesting things that comes up here, the question that comes up sometimes is, if something's a deal breaker, should you raise it right away? And it's really a case-by-case situation here. If you know that you're not willing to move forward on a transaction because of a specific deal point, and you know the other side considers that deal point important as well, you may want to just raise that right away. Instead of trying to sneak it in or drop it in later, raise it right away so you can avoid wasting everybody's time. But there are certain circumstances where, for instance, maybe the other side hasn't raised an issue. Maybe the other side, you don't know how serious they consider it. There may be such things as the scope of any type of post-transaction restrictive covenants. You may want to engage in some line of business that's not directly competitive, but you think, okay, if I raise this now, the other side is going to object and we're going to be arguing about it. I'll hold off and I'll drop it in at the end. Sometimes based on strategy concerns, there may be a reason to hold off on certain key issues and drop those in later if you think it's something that the other side's not going to look at and it's going to cause them to walk away. So it's really a case-by-case circumstance there. I also put a note down here at the bottom when you on financing and earnouts. And in healthcare transactions, again, because it's such a highly regulated environment, you're selling personal services and goodwill of a practice and the relationships that you have with patients and with the community. And in those types of services transactions, it's often common, for instance, with lawyers or accountants or other professionals, where you will have an earnout provision for a period of years where the selling professional makes some type of earnings based on the business that continues to come in after the sale. Those types of transactions are typically frowned upon, or at least need to be scrutinized very heavily in healthcare because of the regulatory environment. Anytime you have a situation where a selling physician can make referrals to the practice after the sale and influence his income, essentially, or his remuneration from the sale, you have a potential kickback issue based on referrals, both under the federal anti-kickback statute and the state corollary. And if it's for designated health services, you also have a potential Stark issue. So we don't see deals structured in healthcare with earnouts unless those have been heavily scrutinized. So if you're involved in a transaction and that's on the table, it's not going to be uncommon to have seller financing. It's not going to be uncommon to have a promissory note or a pledge agreement. But if there's an earnout provision, you need to take a hard look at that provision and make sure that it's not going to raise regulatory issues. Similar to that, and a little bit more nuanced, sometimes you have reps and warranties that can also affect post-sale, the final post-sale benefit to the seller, and those sometimes can raise concerns as well. But the big one I want to point out here is earnouts in the financing pieces. Now, I mentioned your confidentiality provisions, and here's the main provisions you see: confidentiality and non-solicitation. These are generally going to protect the seller because you don't want a buyer coming in, poking around, looking at your books and your records and who your customers are and your customer lists and your employees and what you pay them, and taking that information and using it to compete against you. So it's common to have a confidentiality provision and also have a provision for non-solicitation of both employees and customers. You also want to make sure that those provisions survive the termination of the LOI if the deal doesn't go forward. You don't want to have the letter of intent be terminated by the parties, or both parties agree to walk away, or even a purchase contract with a due diligence provision that gets terminated. And if those provisions don't survive the termination, what happens after that? Can the buyer who was poking around go in and now solicit your employees and solicit your customers and your patients and so forth? So in order to protect that, you have survival provisions even in the LOI that will say, while the LOI may not be binding, they're typically referred to as non-binding LOIs. It gives both parties an opportunity to look at the transaction and decide if they want to move forward. It gives the buyer an initial due diligence period. There are going to be surviving transactions that you need to be aware of that are legally binding. You also commonly see a no-shop clause, and that's generally for the buyer's protection. The buyer doesn't want to come in and start looking around, make an offer, put together an LOI and get the price and the business terms put together, and then have the seller go out and shop that provision for better deals. So it's not uncommon to see something like that in the agreement as well. So you see confidentiality, NDAs, and no-shop clauses. And I hit on these other issues here already with the survival provisions. Point number 2. So first is the LOI. The second point, honesty. I have seen probably the issue that I've seen most often come up with a transaction that goes bad, where somebody wants to consider filing a lawsuit after the fact, is where they think that their counterparty was not honest with them on the front side of the transaction. Usually it's some type of alleged misrepresentation by the seller. If you're the seller of a transaction, you're going to make representations about revenues or some other key figures. Make sure that you can back those up. If you make them in your initial sales pitch and you can't back them up in due diligence, you could lose face and cause the parties to waste a lot of time before they walk away. It's also going to raise concerns about your credibility. Even worse, perhaps, is if it doesn't get caught in due diligence and you make representations that are directly contradictory to what later turns out to be true facts, you could be sued for fraud or fraudulent inducement or some type of misrepresentation claim. You will see purchase contracts will typically have some provision in the contract that says it's either referred to as an integration clause or an entire agreement clause that says all of the terms and provisions that the parties have relied upon are encompassed within the agreement. But there are exceptions to that. One, if you don't have that clause, then it may not apply. Two, if there's a point that was made during due diligence or while the parties were discussing putting together a contract in some phase and And it turns out that a direct misrepresentation, a fraudulent misrepresentation was made. Somebody gave somebody false numbers, for instance. That will likely come back and be a point that's raised in a post-transaction lawsuit, and courts often recognize an exception to the integration clauses to allow those fraud claims to go forward. I've been involved in several of those cases, both on the plaintiff side and the defense side. So it sounds pretty basic, I know, but don't rely just on, well, this is what's in the contract and they sign the contract and that's it. If you make a direct misrepresentation, it can come back to bite you. Similarly, if you are relying on a specific representation and it doesn't show up in the purchase contract, make sure you add it. It should be a representation of warranty in the agreement. It could be something as simple as, so-and-so promised me this, and we had multiple email exchanges about it. Then in the most rudimentary fashion, get that confirmed in the email, print the email, staple it to the agreement, refer to it in the agreement to incorporate the representations that are made in the email, and say in the agreement that the seller represents and warrants that these representations in the email are in fact true and the buyer is relying upon them. Again, just you can do it in much more elegant fashion. The attorneys typically will, but you want to make sure that those don't rely on promises that are not in the agreement. Add them to the agreement. All right, point 3, pardon me, I want to take a drink of water. Stock sales or equity sales. So again, as I mentioned, stock, shares, membership units, these are all essentially equity pieces of the larger unit. An equity transaction involves the sale of the stock or the equity in a transaction, where an asset sale can be all of the assets or the assets sold piecemeal. The buyer can buy some of the assets and maybe leave some out. There may be specific reasons why the parties don't want to include all the assets. Some of them may come with attachments or encumbrances, or some of the business assets used by a practice might be leased. And so there may be reasons you want to keep those out or not include them. But that's the general difference. From a buyer-seller perspective, buyers often prefer to sell equity because they're selling the entire company, including all of the liabilities. Or, pardon me, that's buyers. The sellers typically want to sell the equity of the business or the entire company and sell the assets and the liabilities. The buyer, if they buy equity in a transaction, they are taking the business with all of the hair and the warts on it. So they are getting it with all of the business assets and all of the business liabilities. Now you can account for those with, again, reps and warranties and indemnity provisions, but understand from a high level that that's the main difference. The buyer in a equity transaction is taking on more potential liability. There are tax considerations. I'm not going to go into tax details. I'm not a tax attorney. We do have tax attorneys here in the firm. We also typically work with parties and their tax advisors. But from a general standpoint, sellers often like equity sales because there's long-term gains tax, where an asset sale can result in regular assets that are sold for more than whatever their depreciated value is, which may be zero in a practice. Those assets are going to be taxed generally at ordinary income tax rates. There's some exceptions to be aware of for goodwill and intangibles. But again, what I want you to take away from this today is that the tax considerations are something to be seriously looked at, and this is an area where, regardless of the size of the transaction, you really want to seek professional help and get advice on that. There's another reason I put down here is this, continuing with the existing IRS tax ID number. Again, because of the unique nature of healthcare transactions, you're transferring not only business assets and the patient records and the relationships and the physical assets in a practice, but you're also transferring contracts, payer contracts with private insurance companies, contracts with vendors, contracts with Medicare and Medicaid and other government payers. And sometimes there can be a delay or it can be a little more cumbersome depending on the type of transaction and what state you're in, particularly with Medicaid and with some private payers. the sale of a business where you're selling the entire business, including the EIN, makes for a smoother transition, because if the EIN is not changing, then you're not changing the party's not changing. It's going to be under the contract with the third-party payer or other third party. And if that party is not changing, sometimes the requirements are less with respect to notifying third parties. For instance, here in Florida, if you're going to engage in a transaction and you're transferring your Medicaid contract, we just went through this, the requirements are going to be different if you are keeping the same tax ID number than if you're going to be a buyer of assets and you have to acquire a new Medicaid contract under a new Medicaid provider number and a new tax ID number. So there are certain circumstances with respect to healthcare transactions where it may be advantageous to do an equity sale. Again, it depends on the specific circumstances. But again, usually you're going to have the seller's going to prefer one side and the buyer's going to prefer the other side.
We have a question.
Yes, sir.
So what are the assets being sold? Workforce in place, patient lists, enterprise goodwill, website, things like that?
Sure. Yeah. Name, any trade names, trademarks, other intellectual property. You would have, as you just said, you're selling the patient lists, your rights under the contracts. Oftentimes you may see equipment. Sometimes the equipment will be owned, sometimes it will be leased. And understand, when I mentioned earlier, I'm glad that question came up. If you're selling, for instance, equipment that's subject to a lease, even if the buyer is just buying the assets, you're still taking those assets subject to those encumbrances. So if there's a lease attached to those assets, you're either going to have to pay that lease, or the leasing company probably has a right to come take the assets. So you need to identify those in the purchase contract. And that's, again, that's the difference between equity and an asset sale. With an asset sale, you can piecemeal out some assets. So for instance, maybe the buyer doesn't want the name, so you're not going to assign that. Or maybe there's certain intellectual property, maybe there's software that's been developed, or some other tangible property, computers or other equipment that the buyer doesn't want to take. Those can be pieced out in an asset sale, where the equity sale, you're essentially selling the whole kit and caboodle. Good question. Thank you for raising that. All right. So I mentioned in an asset sale, or under the tax considerations between an asset and equity sale, you have sometimes different treatment for goodwill, for intangibles. You may also have different treatment for specific non-compete agreement in connection with the sale of a healthcare practice, and that will be treated differently. Often the non-compete is going to be considered regular income. So the seller under the non-compete is being paid for not competing, and the buyer that's paying for that is going to be able to deduct that as an expense. And so that segues us into a discussion on one of the topics. This is one of the hottest topics, comes up in employment and in sale transactions, is restrictive covenants. So I think most people are familiar with the general structure of a non-compete agreement. It has to be reasonable in geographic scope and in time, but consider other restrictive covenants, some that are even sometimes more important than your non-compete agreement. Non-solicitation, or what I like to call sometimes anti-piracy, depending on how you use it in agreement. That can apply to both employees and to patient relationships, or in other transactions to customer relationships, sometimes referral relationships, depending on the transaction. You definitely need a provision in there that essentially restricts the seller who has an existing relationship with these parties from selling the business and turning around and recruiting their employees away, or going after the same patients where they already have a relationship. So it's going to be very common that you're going to have a non-solicitation and or anti-piracy, you can call them one or the other, that applies to both employees and to patients. You will also oftentimes have confidentiality provisions. Obviously, certain records need to be kept confidential. Maybe you want to keep the deal terms confidential. Maybe you want to keep the deal confidential except for parties that need to know, and those parties might be, besides employees and maybe government agencies and others, maybe you want to keep it confidential for a certain amount of time for strategic reasons. So you'll have sometimes that in your restrictive covenants. And then of course, the one that's talked about most heavily and probably litigated the most is your non-compete covenant. Again, geographic scope and length of time are key components, but one that I see gets overlooked a lot and people don't spend enough time on is the scope of competitive activities. So you often see some type of provision that says that so-and-so, whether it's the employee or it's the seller, agrees not to engage in any competitive activities for 2 years, or under a sale transaction, it can be up to 5, which is presumptively reasonable in Florida. And the geographic scope might be miles or kilometers or within a certain distance from any active office or within a certain metropolitan statistical area. The parties will put a lot of thought into those provisions. And they do have to be reasonable in order to protect a legitimate business interest. But competitive activities is often vague. And I see parties argue after the fact over what is exactly a competitive activity. If you say, okay, you seller can't engage in any activities in the healthcare industry, what does that mean? Your seller can't teach or volunteer services on a pro bono basis, or act as an expert witness, or consult. So there's a lot of other issues that can come up, and I've had clients that we've talked to say, Eric, after this is done, I'd really like to teach, so I need to make sure that that's carved out. Well, then by all means, put something in the agreement that says, notwithstanding the foregoing, buyer and seller agree, the seller can teach such and such, or whatever it is that you want to do as a seller. Make sure you have that carved out. The more time you spend on that, again, the less time potentially fighting or wondering if you even have an issue after the fact. And finally, the last of our 5 points is who's on your team. Who's your team? You should have an accountant or some type of somebody with tax expertise and financial expertise to help you with due diligence and to review the books, make sure everything looks kosher, to advise you on the tax considerations of a transaction. Obviously, lawyers who are familiar with these types of transactions. We do it here in the firm. You can find somebody and find somebody that has experience navigating the regulatory environment in healthcare and through the corporate and tax issues that come up with these types of transactions generally. You should have typically on your team a banking advisor or banking contact, financial contacts. Insurance is very important. It's nice to have your own insurance agent or contact. Somebody, what I like to do is I have a couple folks that I work with or rely upon. I'll just send documents, send policies over to them, or send provisions in contracts, requirements that people put in contracts, and send it to the insurance agent and let them take a look at it and rely on their expertise to say, yes, this is how we're going to satisfy that, and this is what we're going to do. Understand, and this is again, for folks who haven't been through these transactions, one of the biggest mistakes is do not rely on the other party's representatives and advisors. Don't think that if you're the buyer that the seller's lawyer is drafting up a document and the seller's lawyer is going to draft it fair to you or make sure that it has all the stuff you want in it. Your counterparty's advisors do not represent you. In fact, for lawyers, it is a conflict of interest to represent the buyer and the seller in the transaction. Can't be done. I hear people say that it can be done, that the lawyer is just going to represent the transaction. I don't know how you represent a transaction and have a fiduciary relationship to the transaction. I don't think you can. You have to represent a party to the transaction, and you can't represent parties on the opposite side of the deal. So your counterparty's lawyer, your counterparty's advisors are not yours. Also, the practical benefits. It's nice to have somebody that you're afraid to raise an issue, so you get your lawyer, you get your accountant to raise the issue. Even if you relay it from them and say, well, I'd love to do this, everything looks great, but my lawyer says this. And another consideration is if you're engaged in a conversation. If I'm talking to my client's counterparty or their representative, and a question comes up that I don't know the answer to or may not be sure how to answer, I can say, I've got to talk to my client and get back to you on that. If you're the one who's the client, you're supposed to have the answer, it may look a little strange. You may feel like you get put on the spot. So there's some practical benefits to having somebody represent you as well. Finally, I've got time for if there's any questions that pop up, I'm happy to take those. And it's 12:29. I'm going to go for about 2 minutes here. I'm going to hit a couple of these bonus issues. Avoid general partnerships. Why? Unlike limited partnerships and limited liability partnerships and other limited liability type entities, in a general partnership, all of the partners are liable for the partnership debts and liabilities, as well as the individual debts and liabilities incurred by other partners that are incurred in the scope of the business. That sounds very broad and it sounds very vague, and it is both. And rather than try to explain the nuances of that and tell you how to avoid it, the easy way to avoid it is to avoid anything that looks like a general partnership or a sole proprietorship. You should engage in these transactions through a limited liability entity. We like LLCs for a specific reason, but there are times that other entities will work. You should, I'm going to skip dispute resolution mechanisms. That's self-explanatory. If you got a question on that, ask me afterwards, shoot me an email. Two other interesting issues. One, if you're buying a practice, and I unfortunately had a client, or fortunately, had a client, went through this a few years ago, bought a healthcare related practice, and also acquired an interest. It was a lease with a purchase option in real estate, and entered into that lease with the purchase option as the same entity that was operating the practice. And a fight broke out over the exercise of the purchase option because of the value of the property. And now the client was in the fight with his business and with the seller. And the problem there is that now if you end up in litigation, as we did, now you have a lot at stake, because if you are the business running the particular practice and you are also in litigation over the rights to the building, and there's an attorney fee provision or some other potential liability, and you lose, your practice can be exposed. Meanwhile, the seller probably just owns that business and entity. The only risk the seller has is the entity that owns the piece of real estate itself. And if you had, for instance, created a new entity, such as ABC Real Estate Interest 1, LLC, to enter into the purchase option, now that's the party that is entering into the agreement. And if there's a breach or an alleged breach under the agreement, that's the party that's litigating. What's the risk if that party goes to trial and loses and is exposed to attorney's fees? Well, there is no risk. There's no, unless you can tie it back to the practice. But as long as you keep it as a separate entity, you've now insulated yourself from liability by using a second entity. If you're going to buy real estate, enter into a real estate contract, if there's any type of long-term exposure or other issues, it should be at least in a second entity. Luckily, in that situation, we did go to trial after 3.5 years and a couple $100,000 in attorney's fees, and we did win, but it puts a lot more pressure than if we knew that our downside risk was minimal. And then successor liability through continuation theories, de facto merger, etc. I just want to point that out, that there is a chance you can buy assets. If you're looking at a transaction as a way to escape liability, I'm going to sell all of my interest into another entity, and I'm going to take stock in that entity. I'm going to be an employee and a director, and all my employees are going to move over, and I'm going to take the business with me. And it looks a lot like you're the same entity, just operating under a new business name or entity or regime. The law covers that, and there's all types of discussion. We could probably do a whole half hour, an hour, just talking about continuation theories or de facto merger theories. Just want to point out that if you are engaging in a transaction to try and escape liability, you're probably not going to be able to, and you need to proceed carefully. So we do see that sometimes where a seller wants to sell for thinking they're going to escape and just continue with the assets and not take the liabilities. It doesn't work that way. If you're going to sell assets in an asset sale, it has to be to an independent third party generally.